Hey everybody, I hope you're doing well. So today we're going to be talking about Jacobson v. United States, which is an entrapment case. And the court goes through the discussion of what the government has to prove when entrapment is alleged as a defense. Now, entrapment, just to make this a little bit easier, is basically where the government does something to induce you to commit a crime, and then you do commit that crime. That's an actual defense. It happens on occasion. Before we hop into the facts, though, I want to say hello to everybody because we're almost at 100 subs, which is insane. A few more of you have joined up since we did the last video, and so I want to say hi and welcome. But let's go ahead and talk about Jacobson. And fair warning, the facts on this particular case are a little, well, grody, a little gross, so keep that in mind as we go. A man named Keith Jacobson lived in Nebraska taking care of his elderly parents, and in September of 1987, he found himself indicted on a violation of something called the Child Protection Act, which criminalized the knowing receipt through the mails of a visual depiction that involves the use of a minor engaging in explicit sexual conduct. Basically, it's a child porn statute. Now, Jacobson's trouble began about 2.5 years before. So in February of 1984, he was 56 at the time, and he ordered 2 magazines and a brochure from a San Diego, California adult bookshop. Now, these books were entitled Bear Boys 1 and 2, and these particular books contained nude photographs of teens and preteens engaging in explicit activity. Now, during his trial, Jacobson had indicated he was shocked and startled about the content of these magazines, and that he was surprised. He had anticipated that the individuals inside were at least 18, if not older, and that was not what he received. So keep in mind, we're talking about February of 1984, and at that point, the receipt of such materials was still legal, both at the federal and the state level. That changed 3 months after he received this particular content. At the same time that this new law was taking effect, that it was being passed in Congress, the postal inspectors were looking through mailing lists related to this type of imagery, and they found Jacobson's name on one of those mailing lists. What happens now is about 2.5 years, 2 government agencies and 5 fake organizations, as well as a fake pen pal, where Jacobson was being poked and prodded and, in effect, solicited as to whether he would be willing to violate this new child protection law by purchasing another version of that magazine that he received, the Bear Boys 1 and 2. Now, I'm not going to go into the play-by-play of every letter, every interaction that the government engaged in with Jacobson. I do highly recommend on this one you pull the actual case, which I cite below, because it's insane. So it's a good read, creepy, but a good read. So let's talk about some of the highlights, though, so that you have an idea why the government's rationale is what it is later. So in January of 1985, the postal inspector, pretending to be something called the American Hedonist Society, sent Jacobson a letter, basically soliciting him to join that group. One of the things that was included was a questionnaire about preferences. Now, while Jacobson had indicated he had some interest and preference in homosexual activity of individuals of a certain age, he actually explicitly checked the opposed box when it came to pedophilia. You can't see it right now, but I record in my closet, and the cat just decided to come and visit. Apparently, he's interested in the topic too. But back to Jacobson, because I just kicked the cat out. So here's the thing. After he says, no, I'm not a fan of pedophilia, they basically leave him alone for a while. But then, about May of 1986, a new postal inspector gets his hands on the names in the list, and they go back after him again. And they send out some new solicitations. This is also where the fake pen pal kicks in. They exchanged communications back and forth, and while, again, those letters contained no reference to pedophilia itself, Jacobson did make statements that he had a preference for homosexual activity between individuals in their late teens to early 20s. Again, maybe not to your taste, but so long as everyone's over 18, it's still legal. So now we're into March of 1987, and despite all of these attempts, all the letters, the communications, the fake pen pal, the fake organizations, they had nothing to indicate that Jacobson had intentionally possessed or been exposed to child pornography in violation of this new law. Because don't forget, we haven't gotten to possession being illegal yet, just the transmission of the information through the mail. So the fact that he still has his hands on those old magazines is irrelevant for our purposes so far. And apparently the postal inspectors decided that that wasn't quite good enough, because the Customs Service was also in the middle of engaging in activities related to this new law and trying to tamp it down. And in comes government agency number 2. And we have something of a two-pronged attack here. So the Customs Service sent him a brochure, and that brochure included solicitations to sell photographs of young boys engaging in explicit activity. Now, Jacobson ordered those images. He purchased them, though obviously the order was never filled by the government. At the same time, the Postal Service sent him a letter basically saying, there's a way that we have to get around customs and this particular issue. In looking at that letter from the Postal Service, Jacobson ordered a catalog and then made a purchase of something called Boys Who Love Boys. The government entities created something, sent it to his local postal office to be picked up, and at that time he was arrested. So Jacobson was asked during his trial why it was he had placed this order at all. Why had he gone ahead and punched the button, as it were? And what he said was that the government had actually piqued his interest. He wanted to know why it was that this material was causing so much trouble and what the hysteria over pornography was. Apparently, it didn't describe the actual nature and content of the interaction, of the activity, and so basically the government piqued his interest and he said, oh, why don't we take a look? Now, it should also be noted that when he was arrested, the government did search his house. Right? They went to go see what else he had. And while he did have those 2 original magazines, there was nothing else. They had the catalog that they sent him, but nothing else. He didn't have other pornographic material related to children in the home. Now, obviously, because we're here, Jacobson was convicted by the jury, and then on appeal, the appeals court was split in its decision, but upheld the trial court's decision. They found that the government had carried its burden by proving beyond a reasonable doubt that the petitioner, Jacobson, was predisposed to break the law and had not been entrapped. So taking this up to the Supreme Court, the court opens up acknowledging 2 things. Child pornography is bad, which it is, and cops are able to use undercover tactics to enforce the law, which they can. But they were very clear to say that that doesn't mean that the government gets to originate the criminal design, implant in an innocent person's mind the disposition to commit that crime, and then induce them to do so that the government gets to prosecute them. And they remind everyone of the standard when they say that where the government induces someone to break the law, and the person does so, the government has to prove beyond a reasonable doubt that the defendant was disposed to commit the criminal act prior to first being approached by government agents when the perpetrator raises an entrapment claim. So, for example, if an undercover officer simply goes out and offers to sell somebody drugs and the person does so, that's not entrapment. The police haven't done anything other than offer the ability. Now, if the officers start sending information out going, you want drugs, oh, you really, really want that drug, and then they walk up and they start waving the meth under your nose, saying, oh, you want to buy this, don't you? And you do, that's a different animal. And in this particular case, for Jacobson's purpose, the government didn't even bother trying to say they didn't induce. They admitted it. They went ahead and said, yep, we induced him. The problem isn't that we induced him. The problem for him is that we met our burden, and he was predisposed before we bothered with him to engage in this crime. Therefore, his conviction should stand. And the court basically said, well, government, if you had simply offered him the opportunity to order this illegal material through the mail, and he'd done so, then ignorance of the law being no excuse, he's presumed to know it would be illegal, and you'd be fine. And probably the jury instruction on entrapment wouldn't have even been warranted. But that isn't what happened in this case. They didn't just offer him the pornography. No, for 26 months or so, they basically shoved it under his nose, all the while also going through the trouble of trying to tie this material to other values like limited government intervention, free speech, etc. Now, the prosecutor tried. Heaven help him, he tried. He raises two categories of argument when it comes to the predisposition argument. One, the evidence that was developed prior to the Postal Service's little mail campaign. And two, that evidence that was developed during the investigation itself. Now, it ends up falling flat because the only evidence from before the mail campaign was the transmission of those two catalogs. At the time, remember, the mailing of the catalogs and the possession of them were not illegal, and you cannot presuppose that an individual engaging in legal activity will then still engage in that activity while it's illegal, because generally speaking, people follow the law even where they disagree with it. And the court also made a point of saying that the possession of that magazine was of little probative value because all it really showed was a predisposition to view sexually explicit materials that were responsive to his particular taste. So that knocked out the pre-investigation evidence for purposes of this disposition evaluation. The second was what was developed during the investigation itself, and the court said that that doesn't cut it either. Basically, Jacobson's responses to all of those fake communications, whether it's the questionnaires, the flyers, the catalogs, the pen pal, all of it basically showed, at most, an individual with certain inclinations involving viewing preteen sex and promoting particular lobbying agendas. Because again, remember, the government was including language about the government intervening in your life and how it should be wrong for them to do so, and this material should be legal on free speech grounds, etc., etc., etc. But the court made the point that there was nothing in his responses to indicate that he would commit a violation of the Child Protection Act through the mail with just that information. But again, there was nothing in those communications that would indicate that he would be predisposed to engage in a criminal violation related to child pornography. The court also did take a moment to make a point pretty clear, and that is that the government is not in the habit of dealing in people's fantasies. As the court said, a person's fantasies are his own and beyond the reach of the government. What's in your head is your business. It's what you do that the government cares about, or at least what the government should care about. The government then took a moment and turned its focus toward the content of the materials that the government was sending Jacobson. And they made the point that the entities that the government set up and the material that they sent him was intended to excite his anti-government sentiment regarding things like censorship and liberty, financing its efforts through the catalog sales that they were trying to get him to buy, and similar statements. And while he did respond to the communications, the court said that the quick responses to the statements, to the solicitations, in and of themselves aren't enough to establish beyond a reasonable doubt that he was predisposed prior to that government action intending to create the predisposition. The thing is that the evidence that he was willing to do so, the actual purchase where he then had it mailed to him, didn't occur until after 2.5 years of government intervention, where the government tried to convince him that he had the right or should have the right to engage in this very activity prescribed by law. The law enforcement officials went too far when they implanted in the mind of an innocent person the disposition to commit the alleged offense and to induce him into commission in order that they may prosecute. Basically, this is another check on the government because, as they say, where the government's desire for conviction leads to the apprehension of an otherwise law-abiding citizen who, if left alone, likely wouldn't ever run afoul of the law, obviously the court needs to intervene there because the government is overreaching and imposing itself improperly on the citizenry. And in this particular instance, the government didn't meet its burden of showing beyond a reasonable doubt that on his own he was predisposed to violate the Child Protection Act and engage in the transmission of the sexually explicit materials. It was only after they spent 2.5 years poking at him and sending him things and targeting the language in such a way as to induce him to engage in the activity that Jacobson actually did, and they then arrested him. They failed to show that he would have done it on his own, and as a result, the government failing to meet its burden means that his conviction was overturned. Well, that was Jacobson v. United States, a rather unpleasant fact pattern if I do say so myself, but an important point. Entrapment is one of those defenses that you hear with some regularity, so let me know what you think. Was the government right to set up this string of information that they sent him to see whether he would actually bite, or did they overreach? If so, why? I'd love to hear what you think, but until we are together again, I hope everyone is well.